Okay, hi everybody. I am back with your next set of questions. Now, this exam was supposed to take place in December of 2024, but it took place in January of 2025. Let us quickly start. I have again divided every set into 33 questions. Now, which of the article of the United Nations Charter sets out the principle on which the United Nation is based? It is Article 2. I'll explain you why. Now, under your United Nations Charter, you have Chapter 1, which talks about your purposes and principles. Under that, you have Article 1 and 2. Article 1 specifically talks about your purposes. In total, there are 4 purposes, and Article 2 talks about principles. In total, you have 7 principles. So, sets out the principles is Article 2, option number 2. Next, you have your case law and you have to match it with the theme. Now, if you know Vishakha was the state of Rajasthan, it is pretty self-explanatory. Here C is option number 1, safeguard interest of working women. Also, People's Union for Democratic Rights versus Union of India is also called PUDR versus Union of India. It is a 1982 case. Next. In your 53rd question, you have to match the act with the provisions on penalties. Right when you read the Forest Conservation Act, your section 3 predominantly talks about the constitution of advisory committee. I don't understand how they have synonymously used the constitution of advisory committee as penalties. That is my only question here, and that is the only confusion that is in my mind, and I want to understand if anybody of y'all know, or maybe I'm missing out on something, because when you open Forest Conservation Act and when you read section 3, there is no section 3A and 3B, but the only option correct here is option number 4. Apart from your A option, all your other options are aligned perfectly. So your Wildlife Protection Act 1972 here is again your B is section 51. Your Environment Protection Act 1986 is section 15. Then you have the NGT Act 2010. It is section 26. So 53 is 4. Just a little confused here. Moving on, in Canada, which document outlines the division of power between the federal and provincial governments? I don't understand why they are so obsessed with putting Canadian-centric and US-centric versions in your admin law under your UGC net exam, but I guess that is their way of making the paper very, very difficult. The option here is British North America Act 1867. Now, IPR theory with the jurist. Personhood theory, A is 3, Immanuel Kant. You have natural right theory with John Locke. So A is 3, B is 1. A is 3, B is 1. 55 is option number 4. Moving on to the next one. Again, self-explanatory. If you know Kyoto Protocol, Kyoto Conference on Global Warming, it is 1997. You have the UN Conference on Environment and Development, 56 here. Actually, B is 3. If you see this, B is 3, 56 is A. UN Conference is 1992. Paris Agreement is 2015. Montreal Protocol is 1987. Now, the fundamental rights under Indian Constitution are grouped under various heads. Mention which of the groups mentioned below is not adequately placed. As per the articles, not adequately placed. Right to equality is correct. It starts all with your part 3 here, which starts with Article 12. Okay. Right to constitutional remedies here is wrong because that is from Article 32 to 35. Right after your Article 35 ends, you have your Part 4 starting. Your Part 4 specifically is your DPSP. All right, so you have part 4 starting with DPSPs. Right to freedom of religion here is also right. It is article 25 and 28. At 25 to 28, that is correct. Next, you have right to freedom. That is wrong because it is from 19 to 20. It is not 19 to 21A. It is from 19 to 22. Okay. Right after 22, you have 23, which is right against exploitation. So this is right. Your not adequately marked answers here are B and D, option number 3. Okay, moving on. Which of the following are true for adjudicating officers under the Information Technology Act 2000? A, B and C are all correct. It is mentioned in your section 46 of the Act, which talks about power to adjudicate. Even D option here is sort of right. They've only messed up with the sections. It is 345 here and 346. Here option A, B and C are correct. 58 is option number 1. As per the Supreme Court of India in the oleum gas leak case, the nature of duty owned by an enterprise engaged in hazardous industry posing a potential threat to health and safety of persons residing in the surrounding area is pretty self-explanatory. It's talking about the oleum gas leak case. It is absolute and non-delegible duty, option E. Option E only. Next, implied conditions as to quality or fitness of goods is given under which section of the Sale of Goods Act 1930? Now it is in your section 16. Section 16 here starts. It's under your chapter 2 under your formation of the contract under conditions and warranties. Option 3 is right. 61, pretty self-explanatory again if you know dishonor of checks. In the NI Act, it is section 138, A being 3, option number 1 is right. Moving on, which of the following state is not included in part 21, which is talking about your temporary, transitional and special provisions of the Indian Constitution? Now, I'll make all your lives easy and I will give you the list of all the 12 states mentioned in your part 21. Alright, let's start with 371, which is Maharashtra and Goa. Then you have 371A, which is Nagaland, 371B, which is Assam, after which you have 371C, which is Manipur, you have 371D, which is Andhra Pradesh, Telangana, 371E, which is Central Universities in Andhra Pradesh. Then you have 371G, which is Mizoram. Then you have 371H, Arunachal Pradesh, after which you have 371I, which is Goa. Right after that, lastly, you have 371J, which is Karnataka. You see, Haryana here is not mentioned in any special provisions. Neither it's getting any recognition under part 21. Let's move on. Which of the following statements are true in the context of form of government in USA and India? So your 63rd question, here the right answer is A is right, C is right and E is right. A, C and E. Option number 2. In which of the following case it was held that an agreement by a minor is void? If you've paid attention in your law school, you will understand that agreement minor void is Mohari Bibi versus Damodar Das Gose, but again to confuse you, they have mixed up the words and of the correct answer. So option number 2 there was right, which is Mohari Bibi. Moving on, which of the following are consequences of breach of contract Now, when you talk about breach of contract, it is your damages in ordinary course. Then you have, if stipulation by way of penalty is given in contract, then penalty is a consequence. After which you have, in quantifying damages, the convenience of non-performance has to be considered. All right. So 65 is option number 2, A, C, and D. Okay. What is the effect of acceptance of offer in the context of formation of contract? 66 here is, a contract is created only after an offer is accepted. So option number 1 is right. Which of the following is not part of specified dower in Muslim law? Okay, you will understand proper dower here is not a part. So actually the correct answer is proper dower. Prompt and deferred dower is a part of your specified law, and dower stipulated in marriage contract is synonymously used here. It literally means specified dower. Arrange the following cases in their chronological order. Okay, let's start with your option E, voting procedure on questions relating to reports and petitions concerning the territory of Southwest Africa. It is in 1954. Then you have your Southwest Africa, option A, 1971. After which you have the fisheries jurisdiction UK versus Iceland case. This is 1972. Post that you have the Western Sahara case, 1975. Lastly, you have the Libyan Arab Republic, 1979. Following this, you realize your 68th question here is EACDB. Now, arrange the following provisions related to void agreement in chronological order. They have been obsessed with putting chronology questions in your exam. Again, it's their job to make the question paper extremely difficult. You start with your option number D, agreement without consideration, 25. Then you have agreement in restraint of marriage, 26. After which you have agreement in restraint of trade, which is 27. Then you have agreement in restraint of legal proceedings, which is 28. Post that you have agreement which is ambiguous and uncertain in 29. So following that, the correct option here is DACBE, which is option number 1. Which of the following international treaty deal with access? It should have been deals. The grammar is a little incorrect. With access to published works for visually impaired and print disabled people. Option number 1 is right for your 70th question. Moving on. Wow. Which of the meaning, what is the meaning of the following maxim? I'm not going to read out the maxim for you guys. 71 here is option number 1. Everything from 71 till your last question is pretty self-explanatory. I will just be giving out the options to you guys. Which theory in IPR is based on the value that the law should not reward creators whose intellectual works harm life, health, liberty, or society in general? Society generally, it is moral desert theory. The limitation of the doctrine of constructive notice is known as which of the following? It is doctrine of indoor management. Okay. 74th. The knowledge derived from authoritative books specified in the first schedule to the Drugs and Cosmetics Act 1940 means what as per the definition in the Biological Diversity Amendment Act 2023? It is your codified traditional knowledge, the correct term, codified traditional knowledge. Which of the following analysis is not true for 5th century BC Greek play of Antigone? It is pronounced as Antigone by Sophocles. This is Sophocles. It is only option E. Antigone was excused by state on humanitarian basis. Antigone and Sophocles. Which of the following are consumer protection redressal agencies under the Consumer Protection Act 1986? 76 is 4th, you have the Consumer Disputes Redressal Forum, you have the Consumer Disputes Redressal Commission, you also have the National Consumer Disputes Redressal Commission, A, B, and E. Next, the jurisdiction of the ICJ is based upon which principle? It is based on the principle of consensual basis. Official language of ICJ is both French and English. Again, you have to match the article with the purpose. You know you have 4 purposes like I mentioned in your first question. Article 1.1 is to maintain peace and security. Article 1.2 is to develop friendly relations. From that you realize A is 3, B is 1, A is 3, B is 1. Again, when you see article, both of these are showing similar options. Article 1.3 is your to achieve international cooperation in solving international problems. Lastly, you have Article 1.4 to be a center for harmonizing the actions of nations in the attainment of common ends. So for your 79th question, it is option number 1. Okay, who amongst the below mentioned has the power to make provisions of preparation of electoral rolls, delimitation of constituencies with respect to elections to state legislatures? If you're good at Consti law and Pol Science, you will know the option here is Parliament by law. I am going very fast because my battery is about to die. Plus, the next question here is who among the following is currently, as of Jan 2025, serving as judge of ICJ? It is Dalveer Bhandari, option number 3. Let's quickly do last 2 questions. Which of the following does not truly describe the nature of administrative law? Okay, so you have C, administrative law does not include control mechanism against arbitrariness. This is not truly described. Plus you also have administrative law seldom addresses reconciliation of power with liberty. So option 3. Which of the following are the dates in which India signed and ratified the 1949 Geneva Conventions? It was signed on 16th December 1949 and ratified on 9th November 1950. I will see you next time in part 2. Thank you so much for watching.